thought it would be a good idea for this webinar to be joined by Sonia and Abigail, because of the type of work that they do in at FTA Law. In particular, they have lots and lots of experience with associates and what's going on in practice and when it turns into a dispute. And I know there's an awful lot of queries that you have with regards to associates and what's the right and wrong thing to do. So I'll let you introduce yourselves first. Over to Sonia.
Hi everyone, it's nice for you to all join us. My name's Sonia and I head up the dispute resolution team here at FTA Law. As Sarah just briefly touched on, we're involved when disputes arise, and we're here to try and resolve those disputes for you in any form of contractual arrangement.
Thank you. And we're also joined with Abigail. Abby, do you want to say a little bit about yourself?
Hi, I'm a senior paralegal in the dispute resolution team, so deal with a lot of associate disputes on day to day. This is quite a lot of experience on our part from the last year has definitely made things increase the dispute side of things a lot.
I think definitely you're right there, Abby. I think what I'm finding, not only from associates, but from employees as well, that there are a lot of disputes happening. And that's because, let's face it, the guidance that's been provided to us over the last year hasn't been very clear. So when you don't get clear guidance, that means that people interpret it in different ways. But also, I think there's a lot of external factors affecting people's behaviours at the moment. So a lot of people are quite upset with the situation. They're not able to relax as they used to be able to, although we are lucky, aren't we? Because we have opened up a little bit now. So we can start drinking outside if you're brave enough and going to the gym. So obviously, there's lots of factors which does mean that unfortunately people are getting themselves into disputes. So the first one that I want to touch on that I've been dealing with a lot this week, and I saw on a lot of the forums, is disputes with employees who have less than 2 years service. So I do think that there is a little bit of a myth out there that if an employee's got less than 2 years service, basically you're free to be able to dismiss that employee without there being any consequences. And that's not quite right. It's not as straightforward as it may seem. So the reason why 2 years is important is because after 2 years service, an employee receives unfair dismissal rights. So what we mean by that is that if they feel as though they've been unfairly dismissed, they can bring a claim in the employment tribunal, and they can be unfairly dismissed either because procedurally you don't dismiss them correctly, or because your reason for the dismissal is incorrect. Before 2 years, there are 74 other claims that an employee can bring. And it may be that they have automatic unfair dismissal rights. So, for example, if they were dismissed because they thought they blew the whistle, a whistleblowing situation, or they were dismissed because they'd raised health and safety concerns, or they tried to enforce a statutory right, or the big one, discrimination, if they felt as though they were being discriminated upon, they can still bring a claim in the employment tribunal. So our advice, and my advice, would be that in that first 2 years of service, if you're wanting to bring somebody's employment to an end, whether they're within their probationary period or outside the probationary period, it's always a good idea to have some sort of procedure in place. And what I mean by that is that you've got to manage the employee's expectations. And that means that if there are performance issues, okay, you may not be going on to a full performance improvement plan with them in the first 2 years, but you need to be having conversations with them so that they understand that there are issues, so that if you do come to dismiss them, it's not such a shock. We find that people who receive claims in the first 2 years of an employee's service, they receive them because the employee isn't aware that there are issues, doesn't know why they've been dismissed, and then they look for another reason. For example, they may say, well, I haven't really done anything wrong. You've not told me I've been underperforming. The only reason I can think that you've dismissed me is because I'm a woman, and therefore I'm going to make a sex discrimination case. So just be careful in thinking that in the first 2 years of service, it is easy for you to dismiss. I would always say make sure you take advice and follow your own procedures in that regard. So Sonia, if I come to you, what have you been dealing with this week?
Well, surprisingly or surprisingly not, we're still having a lot of disputes arising in respect of what NHS associates should be paid or have been paid. It's obviously a very hot topic, and it has been a hot topic for the last year now in respect of that. So quickly going back to March, obviously the guidance has now changed from March. We're now in the new start of the new contractual year now, so obviously it's changed, but I think the spirit of the principles still remain the same or very similar in terms of associates should be paid as what they previously have been paid. Obviously contract holders, they've still been getting their contractual monthly payment, so that on the provision that they're getting that payment, associates should also be getting their usual payment too. The position now from April to September is contract holders have to meet a minimum requirement of 60% UDA to meet their UDA target. Again, associates should continue to be paid the same amount as well. I think the difficulty that we've had is that the relationship between associate and practice owners, they're not engaging with one another really, and I think a lot of issues that we've found is that practice owners potentially maybe going off and using their own little model in terms of how they should be paying associates, but our advice and guidance has always been you must be paid paying associates, and associates must be paid at the previous levels as they should have been.
The difficulty, Sonia, is that some associates have a lack of understanding of what's expected of them. So they've heard this 60% and they think that that's their target to reach. And even before the 60%, the 40%. 45%, they were downing tools once they felt as though they'd done enough. What was your advice in respect of that?
So that's a very important one. I know generally practice owners have been paying associates correctly, but there have been the minority that haven't, and there have been situations where a minority of those associates have been what would say downing tools when they think they've reached that target. But what it's important for associates to understand is that they can't just stop working once they've reached that target, because it's a minimum requirement, and the practice owner will continue to only receive the full payment if it reaches above the 60%, if they achieve above the 45-60% to be achieved. So full payment is only made once they've reached that. So I think that's very important actually. And one of the conditions in the new guidance is that they have to prioritize patient care. You have to, so if associates, when they're reaching that target, and not priority and downing tools, that's not in the spirit of the guidance. That's not what it says. You have to prioritize patient care, so you have to continue seeing patients.
Yeah, absolutely. So we mentioned a few times there that it's guidance that we've been provided with, and I think that's really interesting, because as well what we're finding is that some practice managers and owners still haven't put contractual terms in place with their associates, and it's so important to have the paperwork in place. So to my mind, and Sonia, you can butt in here when I miss a document out, but we should have an associate agreement drafted. That associate agreement should have or some clauses in that associate agreement should have been suspended because there was no UDA targets when practices closed, and we should have made sure that that was in writing. If there were any changes in the interim and you were making changes to the original associate agreement, notice as per the agreement should have been provided, which is usually 3 months, but it can vary from practice to practice, so do bear that in mind. I think some people get 3 months in their mind and they think that's it, but look at the agreement, that's the starting point. Then when they introduced the 45% minimum, there should have been a variation, and it should have been the suspension clauses should have been revoked. And then there should have been another variation again when the new target came in. So there should be lots of paperwork in place in respect of the associate, because that creates a contract.
Absolutely. When we're dealing with disputes, it all comes down to what actually have you agreed, what is in that written agreement. So I can't stress the importance of both practice owners and associates getting advice before you enter into that agreement. It's that once you sign that document, it becomes legally binding, and you have to abide by those terms of those agreements. So I always think the disputes that we're assisting with at the moment, it's whereby the clauses are not sufficiently drafted in order, like you said, Sarah, to have where you've had your variations, etc. We haven't had the cushion of having those clauses to rely on. So the ones where we've resolved, and you've resolved very quickly, is when both parties have had advice, understand the terms. Those are the ones where disputes have resolved very quickly and effectively.
And I think as well, it's important that even though when you get a quote for putting the contract in place, some people may look at that and think, oh, that's a lot of money for a contract or a variation. But ultimately, that is so much cheaper than having to instruct someone like yourself, Sonia, to deal with the dispute. And I think dentists always understand this, because we always say, don't we, prevention is cheaper than the cure. Because it is, isn't it?
It is.
And just can you just explain a little bit about how costs work in the county court, especially for associates? And
Absolutely.
I can explain tribunal and employment tribunal disputes, which is different again, which I will come on to. But can you just tell us a bit about county court costs and
Absolutely.
why it's so expensive to get into a dispute?
Absolutely. So obviously, when you're in a dispute with in respect of, it's usually monetary. Because of the high value of certain cases and what you're potentially owed. So say, for example, on average, you're looking at about £6,000 to £7,000, but then on top of that, you'll have other factors to consider as well. There's three courts in the county court that you can pursue a claim in. That being a small claims, fast track and multi-track. Now it all depends on the value of the claim. So if you've got a dispute and the value is less than £10,000, which I'm afraid in the dental industry it's very rare that it's less than £10,000. It usually goes above the £10,000. But in the instance that you do, you're able to pursue a claim in the small claims court. Now it's quite an easy process to do is that, and it's designed for people, litigants in person, to represent themselves. But like I said, it usually falls out of that threshold, and it goes, you tend to fall between multi-track and fast track. And now that you'll have an issue fee to pay depending on the value of it, of the dispute. You can, in small claims, you cannot recover your legal fees either. But then when you're in the realms of either multi-track or fast track, you have got solicitors' costs in terms of obviously drafting your claim form or doing a defence. You've got various directions to adhere to as well, so it can get very costly, and more than often or not, and it's something that I always make sure I tell clients is you have to look at it commercially as well. You do not want legal fees to outweigh actually what the value of the dispute. So costs can get away if you have to issue a claim, and it's something that we obviously try and avoid, and it's something that we can do quite effectively, try and resolve the dispute beforehand, because quite often or not, just by sending a few letters to and from solicitors can have the effect of reaching resolution. So going back to Sarah's point, is costs can escalate, and it can be quite expensive if you go down the courtroom.
What's quite interesting about associate disputes, and Abby, I know you're sitting there very patiently, I'm going to come on to you in a minute and ask you what you've been doing this week, but I think what's really interesting about associate disputes is that they can make a claim either in the county court, or they can make them in the employment tribunal, depending on what they try and claim against you. And in the employment tribunal, each party bears their own legal costs, so you will have legal costs to pay to deal with it, and you can't claim them back from the other side. Well, very limited circumstances where you can claim them back from the other side. You have to claim that they've been vexatious or misunderstood their claim, so they hardly ever get awarded. So I always say, when you are looking at your management insurance or legal expenses insurance, it's always good to make sure that you're covered in respect of employment tribunal claims. And if you use a dental broker, so somebody in the industry who's dentally aware, they will more likely cover self-employed individuals in the employment tribunal as well. So just make sure that you check that when you are taking out insurance. So Abby, what have you been up to this week?
We've had a lot of issues at the moment, with associates and practice owners that have done what they've meant to in the first instance. And I know this comes up quite a lot from the employment side when it's all being set up. They've done what they meant to in the first instance, and they've got an associate agreement. They've got all the right express terms. They know exactly what they want. But then the minute the associate signs the agreement and they start working, they don't apply those from month to month in conduct. And then it comes 4, 5, 6 years down the line, and you suddenly realise you're doing an audit, for example. I've not been applying this charge for the past 5 or 6 years. I could really do with applying that charge now. You're going to end up in dispute at this point, probably with your associate, who doesn't really want to give up thousands of pounds worth of charges that they'd never really realised. I think it pulls up a few issues there. The associate should have taken advice in the first instance before entering into the associate agreement. Again, it's all prevention is better than the cure. The practice owner should have really been applying that from the outset. And this all comes down to it's contractual law, and it's where we get involved, and it's the certainty of terms. So if you're wanting to apply a term throughout the agreement or enforce it at any point, both parties need to be certain of its meaning, its intention, how it applies. Otherwise, you're going to struggle to enforce it. And even if you are successful, because you've had the express term there and they should have been aware of it, you're going to spend a lot of money in dispute and trying to come to some sort of settlement, or may even go down the court aspect. So I think that's been probably something that we touch on quite a lot, but is so common in that instance.
Yeah, absolutely. I think people sometimes don't realise that the contract's the starting point. Whether you've got an associate or an employee or a self-employed hygienist, the courts, whether you're in the employment tribunal or the county court, will look to the contract in the first instance and see what's in there. But then there's other factors that they will look at. So, for example, in an associate agreement, I often say this to my clients, one of the key indicators of self-employed status is the right to be able to put a locum in place, so to be able to substitute. And lots of my clients will say, yeah, draft that, Sarah, make sure that clause is in the contract. And I say, right, okay, fine. How many days do you want the locum, after how many days absence of the associate, do you want the locum to be put in place? oh, I don't know, maybe 14, I'd let them have 2-week holiday, and I put them in and I said, fine, okay, you've got to action this after 14 days. So there's no point having a clause in there that you think is going to protect you and make this employee self-employed and then never actioning it and putting it into reality, because all the courts will do is say, well, that was just a sham. You just put that in there to try and make somebody self-employed, but it's not really the reality. And I suppose in your case, Abby, that's something that they'll look at as well, as in when you put in this charge, was it something that you actually, was it a mistake that you haven't taken it? Did everybody know that you were needing to take it, or is it just a bit of a sham, really? What's the real reasoning behind that clause? And I think a lot of people forget that the contract's just the starting point.
I think that's actually really interesting, because I think that falls down to some of the other queries that we've been getting in respect to retention clauses, and a lot of associates not fully understanding the purpose of why we have a retention clause, because as unfortunately, as we found last year, because of the uncertainty, we saw either practice owner terminating associates' contracts, or even associates terminating their contracts. So we're now a year down the line afterwards, and it's come to the 12-month mark where retention's due, and the retention's being withheld for various reasons. But it's because, and the reason why we're also assisting a lot of clients in respect to this, because they haven't had the advice or fully understood what the clause actually means. So it's again another one that we've experienced quite a lot, and like I said, it comes back to the drafting of the agreement and fully understanding what the clause is.
Yeah, I think that's a really good one, actually, because there are lots of people who retain money, and it's always the person who, so in this case the associate, who will be having to take some legal advice or take some kind of action to get that money back. So actually in this circumstance, if the associate should have really taken advice and understood the consequences of what they were signing, and we often find that lots of associates don't take advice and don't have their agreements checked. So one of the ways that you can push the associate to take legal advice, and bear in mind that it's in everybody's best interest. I think sometimes people get worried about this and they say, oh, I don't want the associate to take advice because they might not sign it. But actually what it does is it means that both parties understand their obligations, and you can even write a clause in the associate agreement saying that the associate warrants or confirms that they've taken legal advice and understand the agreement. And then if you ever get into a dispute, you actually have the stronger case, because they've gone and taken advice in respect of the agreement. So I would encourage that if somebody wants to take legal advice in respect of their associate agreements, that you allow them to, and you shouldn't be worried about it. Do you have any comments on that, Abby?
Yeah, I was just thinking as well, another common area where it's really important the associate takes legal advice is in fixed term associate agreements. I know they're really common if they become NHS, they're trying to get their NHS performer number from conditional to unconditional. I know it's important for the practice owner to tie them in essentially, because they've invested a lot of time and resources and money into that training prospect. But I don't think a lot of associates realise what that means, what being tied in for 18 months or 2 years means, and the fact that they can't just say one day, well, actually, I don't want to do this anymore, and that there is actually a large financial consequence there for them choosing not to carry that on. But we do find often that the associate never realised the consequences at the outset. And then that's just more trouble for the practice owner. It's actually more beneficial for the practice owner to say, go and understand what you're getting yourself into. So I do think it's become so important that they're aware of their agreement.
Yeah. I think that's actually really important, that the point of both parties understanding what they're getting into, basically, because at the end of the day you want to retain that goodwill. Obviously you want the associate to stay. You're not going to you'll avoid getting into disputes if both parties understand fully what they're entering into. So I think it's really important for both parties to get that advice, so you retain that goodwill. You've got a longer standing associate staying with you then, because there's no dispute. Obviously you can't prevent disputes, but it will limit that for you.
Yeah, and I think a fixed term is something that people should be considering at the moment, because I do know that it's very hard in respect of recruitment and for the industry at the moment. My clients' feedback is that they're finding it quite hard to get good staff, good associates, good hygienists and therapists, and they're looking at ways for them to remain in practice with them. And first of all, I think, yes, we can do contractual things and put a fixed term in, but please take advice and do it properly. The worst disputes I see are the ones where they think they're drafting a fixed term and they try and write in themselves the period of time that they're fixed in for, and they forget about the notice provisions, they forget about other clauses in the contract, because let's face it, you're not used to drafting contracts. We do it day in, day out. We know what we're looking for, but definitely looking at something like fixed terms may be something for you to consider in practice, but get them done properly so that there are consequences if the departing party, and it could be a practice owner who decides to opt out early, knows what they're doing. And even if you do enter into a fixed term contract, if it doesn't work and both parties know it doesn't work, you can do anything via agreement. So you don't need to get lawyers involved. If you both agree that that fixed term is coming to an end, you can agree that in writing early, and you can finish it. But I think it's important that the drafting is done properly right at the outset. So just also with associates, whilst we're talking about associates and agreements, something that I've been doing a lot with at the moment is bespoke drafting with social media and what happens with social media. And lots of associates are creating their own brands. Lots of people may go and see a particular associate dentist because they've got a good name in the profession, or they've got 10 million followers on Instagram. So we need to protect the practice in that respect. And I think one of the things that we do need to look at is if they are self-employed, this is a very good indicator of self-employed status, that they have their own brand, their own status in the profession, and it will obviously have a great knock-on effect for the practice because they'll bring money in, they'll bring patients in. But then what happens when that associate leaves? And that's what we need to protect. And there are lots of ways we can do it. And in the first instance, you can make sure that any posts are taken down. We can talk about who owns the IP. Maybe once they leave, it can be transferred across to the practice owner. And there's just lots of ways that we can protect the practice. They may have to pay you to use some of your patients' imagery. Lots of ways we can go about it depending on what's right for you in your practice. But you're not going to find this in a standard associate agreement that you've downloaded from somewhere. These are clauses that need to be properly drafted. Over and above that, we can use restrictive covenants or barring out clauses. And I think lots of people forget about these clauses or think they're not worth the paper they're written on. You can find them in self-employed agreements, but also in employment contracts. And they can be in employment contracts for anybody that may be subject to confidential information or business information. So you need to have a legitimate need or something to protect. So for example, and I'm sorry to the practice managers out there, it may be that you put them in the practice manager's contract because they will be privy to certain information that if they left, you wouldn't want a competitor using or knowing that information. So restrictive covenants, we're seeing a lot more of these disputes coming through. I know you're dealing with one at the moment, Sonia, with regards to an associate who's tried to leave and work within the radius which the restrictions prevent them from working within.
Yeah, so yeah, having restricted covenants is very important because, like you said, when it comes to a dispute, you want to be able to rely on that clause in order to enforce the terms of that clause as well. When you're drafting restricted covenant clauses, it's very important to take into account, and this is what the court look at as well, location. Say, for example, if you're on a high street, obviously there's going to tends to be a lot more dental practice on the high street as well. But if you're in somewhere remote, a reasonable radius may be, as opposed to a 5-mile radius, might be 10-mile radius. So that's why it's very important to have a bespoke clauses drafted in respect to that, because it depends on your practice, what your practice needs, and the surrounding areas as well. So there's lots of factors to take into account in respect to that.
Absolutely. And I think one of the, again, if you take out insurance with and I'm not an insurance broker, I'm not selling insurance, but I just think it's in your best interest to know that if you take insurance through somebody that understands the dental industry, quite often you can be covered for restrictive covenant insurance, because these are incredibly costly to enforce. And even though some people have a good case and they can enforce them, quite often they may not, just because of the expense and the legal fees associated with enforcing these clauses. Obviously, if it's going to affect your business and you're seeing a downturn in your turnover and your patient base coming through, then in those circumstances, you probably would pay the fees to try and protect your own business, but we don't want to get there. We just need to make sure that we've got good restrictions that act as a deterrent to prevent people from doing that in the first instance. But just while we're on restrictions, this is something which is in consultation. So the consultation closed at the end of February in respect of restrictive covenants and any changes that they're going to make. And I haven't seen anything yet about what the findings are in respect of that consultation, and if there are going to be any changes in the law. So just keep an eye out. We'll try and update you as much as possible about the changes with restricted covenants and what's going to happen with them. Abby, what else have you been doing this week?
I was just about to touch on as well the restrictive covenants, the importance of taking advice or having it bespoke in the first instance, because if your term is unfair, so for example, you work, there's only 2 dental practices in your entire area and you encompass the entire that area in your restrictive covenants, that might be seen as an unfair contract term, and then could not be enforceable through the courts or through negotiations. So it's just best to be covered in that instance, that you're making sure you've not got an associate agreement applicable to somewhere in the northeast in the middle of the countryside when you work on Harley Street, for example, and it's just a completely different circumstance.
Yeah, absolutely. And then another point that we should make as well with associate agreement and restrictions is that if you have sold a practice and you're the purchaser, you need to put new self-employed agreements in place to make sure that the restrictions and the various other clauses do apply to you. So quite often, depending on how the practice is bought, so if it's a share deal, slightly different, but quite often the contracts don't transfer in their entirety. So you need to make sure that you put new agreements in place. So if you haven't done that and you've recently been part of a purchase or a sale, it should be something for you to bear in mind. We have a large transactional team at FTA Law, and we work quite closely with them, making sure that our clients are aware of this and what they have to do. But I know that sometimes that's not always advice that is provided until it's too late down the line, and then we have to try and sort it out for them.
Just quickly, just on the final point, I think on the restricted covenant, Sarah, do you know when you mentioned way back about getting advice early and fully understanding it? Because if you have a well-drafted clause in respect to restricted covenant, we found that we're quite successful for preventing that for associate, for example, taking patients with them, because we're able to rely on that. So just by sending a very formal, robust letter, because we're able to rely on a very clear clause, has prevented thousands of pounds worth of goodwill being, taken from the practice, etc. So I think it's just a bit of a minute point, but actually it can turn into a very big point if you just have very good advice in respect to that, because you, at the end of the day, you probably have to have legal representation to help you with that, and it's much better for us if we have a good clause that we can rely on to prevent that from happening.
Absolutely. It may be a minute point, but I think it's a very, very important point.
Yeah, it is.
I think definitely. So Abby, anything else about associate agreements that you've come up with, that you've been dealing with this week?
Well, I think something that will always be just on everyone's mind, always, while the NHS contract exists, is clawback. There'll always be associates, or there'll always be practice owners. In an ideal world, there would be that don't meet the UDA target every year. And when you get to the end of the year and you've got, we know the circumstances where it's not the practice owner's fault. They've got an associate that is highly underperformed. They address that with them. They give them sufficient patience. But what's important is to have that clause there. It's, again, a well-drafted associate agreement. Have that clause there to allow you to claw that money back from the associate, rather than it being a complete loss to the business. So I think that's just a day in, day out issue that we have. But it's always great when the practice owner comes to us, they've got a well-drafted associate agreement. All we have to do then is draft a robust, strong letter that points them directly to that clause, and point out that it's due to their actions, and it does make the dispute end quicker. I mean, if they continue to deny it, it's always going to drag out depending on the person, but it just makes the case so much stronger in the first instance.
Yeah, I think sometimes what happens is that people don't fully understand the clauses in the contracts, and they'll take out certain clauses because they feel as though it makes it simpler. When I've seen contracts come in, and they're supposed to be associate agreements, and they're 2 pages, and I say, why did you do this? Oh, I just wanted it simple. And it's like, it's because there's a lack of understanding about what those clauses mean. Quite often I see associate agreements that refer to employment of the individual. I find associate agreements where the license fee is taken out because they don't understand it or don't understand how it works. And I think it's more important, than rather than you taking things out, such as clawback provisions or overperformance provisions. I see that an awful lot, where they take the clause out that says you won't be paid for overperformance, and then they owe the associate a lot of money because they've actually performed over and above their targets. Rather than doing that, I think it's important that some time's taken to fully understand the ins and outs of a self-employed agreement. And I think that's something that we can really help you with, that as part of, especially for practice managers and practice owners, when you go into owning or managing a business, you don't get taught the ins and outs of an associate agreement at dental school. So I think it's important that you take the time out to look at the other aspects of what it takes to manage and run a business. And this is probably one of the biggest, as in understanding a self-employed agreement. Take some time out with someone like myself where we can go through it and totally understand the agreements that are right for you in your practice. We go through all our associate agreements with our clients to make sure not only that they are understood fully, but also that it includes any bespoke and tailor-made clauses that are right for you in your practice, so that we try and put you in a position to prevent any disputes going forward, because you've got the clauses there and they're well drafted. And also what we do is we help you. So when the associate is saying, or the self-employed hygienist might be saying, I'm not signing this because I don't like the look of that clause, we can go back and we can either explain that clause or we can come to a compromise that suits both parties, so that it never escalates. It never has to get to the point where you're having to deal with a dispute. Quite often, 80-20 rule, you can put everything in place and you'll still end up with somebody who's unhappy, but we try our best to try and manage them out or get them out of the team, because they're probably not right for you in your practice. So we spoke an awful lot about self-employed agreements there, and we did touch on legal fees and how expensive it is and how the things we can do to prevent legal fees. But Sonia, I don't think we can go away from this webinar without touching on a landmark judgment that you have and Abby have been involved in respect of a expense sharing dispute, and you can tell us what happened there and what happened with legal fees.
Yes, that's it. It was a very let's say a very interesting case. The dispute has gone and did go on for quite a few years. Unfortunately, as much as a compromise was tried to reach, it obviously depends on each individual. It wasn't reached, so we ended up issuing. Now the dispute was in respect of an expense share agreement. So the relationship totally broke down, absolutely broke down, and then it became an issue of assets and valuation. We went through a long process, and because the determination, it was in respect of land, in respect of goodwill, we had to issue in the High Court. So this is where it's very important through each and every procedure of such a in matters as such, is to always have that compromise and always make offers to the other party, because I can't stress after having this judgment how important that is, because we were successful in that outcome, it all comes back down to the drafting of that expense share agreement and relying on the provision in there, because for example, first having the right for the remaining partner to have right of first refusal, or it can go to a third party. So the mechanisms of that agreement were very, very useful and was heavily relied on by the judge. Because we had this very well drafted agreement in place, we were ultimately successful in this on behalf of our clients. And going back to costs and why we were successful in recovering the legal fees, which were in excess of 130,000, I believe it was, we managed to recover the cost back for our client, because we made little baby steps by making offers to the other party, and which obviously the court were well aware of because it was put before them. So that's why before you even get to that stage, you must take legal advice to go through each and every mechanism of the agreement.
Yeah, absolutely. So in that case, I mean, we've spoken about associate agreements, but that was an expense sharing agreement. So again, coming back to putting the right documents in place to try and prevent a dispute. So partnership agreements, shareholders agreements, expense sharing agreements. That's what we need to do in the first instance. We can't prevent a dispute, but in that case where there was one, the judge relied on that written agreement. So our clients and their intentions and their instructions in that agreement, the judge agreed with, because it was all in writing and both parties had agreed with. And because your clients had made offers to settle to try and sort this out, the courts take a dim view of people who don't try and sort it out without having to go to a hearing. So what you do is, this is in the employment tribunal and in the county court, is that we would always look for ways to settle. And I think that's really important. A small percentage of cases actually go all the way, like this one did in respect of Sonia's case. Because the courts and ourselves know that it's in your best interest to try and save money, save time, and save a lot of stress by sorting it out early days. And if you don't, you can be penalised, as in this case.
Yeah, absolutely. And how you put those offers across as well, they have to be a genuine attempt to settle as well. I think a lot of people just think by say for example, if the dispute's £50,000, or I'll just offer something very minimal. That's not in the spirit of settling. It has to be a genuine offer to settle. So I think that's really important for everyone to understand. You can't just pluck a figure out of thin air. And like Sarah said, it's not always for everyone, so long as you can try and you can see to try to resolve it, because the courts don't take lightly to parties just running expensive cases without having looked at all forms of ADR, such as mediation, sending out offer letters.
Yeah. So we touched upon recruitment earlier on in this webinar, and I just wanted to talk about a case which I've come across, which is really interesting. And it's actually about a lawyer who went for an interview, but I think it could easily apply to the dental industry. And even though we are suffering at the moment when it comes to recruitment in the dental industry, because there's lots of people moving out of the profession, and I was involved in a webinar the other week where there was a lot of understanding as to why people were moving out of the profession, because there's a lot of PPE, a lot of changes have happened in the dental practice. It's maybe not what they thought they were going into, and there's lots of people having to recruit. And I can't stress enough how you need to have a recruitment policy and procedure in place, and just make sure that you do follow that procedure and take advice in respect of recruitment, because you can easily trip yourselves up and end up with a claim in the employment tribunal during that process. Some people don't realise that applicants are all covered under the equality and diversity legislation. And in this particular case, it's about a lawyer who went for an interview, and he had more than 5 years post-qualified experience. And somebody in their interview notes had written down probably expensive. He didn't get the role because they said to him that they actually wanted somebody who was probably 3 to 5 years post-qualified experience. He made a claim against them for age discrimination because he said he hadn't got the role because they never asked him if he was expensive. They just thought he would be expensive in respect of his salary because of his age and seniority, and he's won his case. So how important is it to make sure that if you do interview somebody who's got more experience for a role, that you manage their expectations and make sure that they understand the salary and the job description and what's expected of them. And if they're willing to do that, we shouldn't assume that they wouldn't want that role, or they're going to end up being more expensive, because apparently that can equate to age discrimination. So another one where I can see why it's a difficult one, because they won't be direct. That's what I would say with their discrimination, but they just didn't realise. And again, in those circumstances, the judge commented about training and equality and diversity training. So again, something we can help you with. If you need equality and diversity training for your management team or for the team as a whole, it's definitely something that we would do with you in conjunction with putting a good, well-drafted equality and diversity policy in place. In respect of employees and recruitment and them leaving the profession, I think it's important to mention here about employee well-being. And just looking after your staff and what you can do. I get asked this quite a lot, to basically up morale at the moment, because morale's quite low, and it's important that you have conversations. And I say, maybe it might not even be communicating one-to-one, but it may be team meetings, it might be emails, telephones, but it's so important that you communicate with your team and find out what's going on and if there are any issues. We've got some initiatives in our firm at the moment, which actually neither Sonia and Abby attended this morning. They must have been too busy. But we, for example, provide personal training on a Wednesday morning. So we have a Zoom meeting, and I know that's easier for us because of the environment, but it may be something that you would like to provide to your staff after work on one day during the week. We provided wellbeing boxes to our staff members. Abby's nodding, so you must have liked that one. What did you get in your box, Abby?
Got some teas and a face mask and some other wellbeing things. It was a nice surprise. Really up to morale.
Just looking at little things that you can be doing just to make the staff feel a bit better about themselves, and thanking them for the work that they're doing is so important at the moment. Definitely. It's not always about money. Lots of people come and say, oh, I'm going to give bonuses, or what can I do, Sarah? I want to put bonus in place. And sometimes they can be good ideas, and we can look at structuring things like that to assist you in your practice, but that's not always what the staff need or want. Sometimes it is, but just be careful when putting bonuses and structures in place. A big one that I come across a lot is that people will have a loyalty bonus, or people who don't take absence, they will be awarded with a bonus, but they are like a hot potato. You shouldn't really have them in practice if you can get away with it, just because if somebody takes a period of absence, you don't always know why and the reason behind it. An employee doesn't always have to tell you the reason why they're taking absence. So, for example, if somebody doesn't get their bonus because they've taken some absence due to pregnancy-related illness or age or disability, or it may be that they've taken some unpaid leave for religious holidays or something along those lines, and they don't receive that bonus, you're opening up a can of worms in respect of discrimination. And discrimination are the type of cases where it's unlimited compensation that's awarded. It's whatever the judge believes is just and equitable on the day. So they are the expensive claims. And so if you are looking at doing anything like that, do take advice and put a written policy in place. So just quickly, before we finish for this evening, if you had one piece of advice, Sonia, to provide to everybody on this webinar, what would you say to them?
I'd probably say is before entering into any form of contractual arrangements with with anybody, is get advice, speak to someone that understands it beforehand. One size doesn't fit all, so you need to make sure the agreement, whatever you're entering into, fits your needs, and you fully understand it.
Thank you. Abby, do you have some advice for the attendees this evening?
I think mine will probably follow the other way. So if you get an inkling that dispute is about to arise, before acting off the cuff, I'd take advice first. It might be that your instinct might be off this time, or we might have a quicker, or someone else might have a quicker, more it's reasonable but easier route to settlement, resolving the issue outcome there. So advice before and after.
I think so. I think that's a really important point, actually, Abby, because the thing that we can take out of it is the emotion. And I think when you're getting into a dispute, whether it's with an employee, a self-employed member, county court, employment tribunal, you have the best contracts in the world drafted, what it will be is emotive, because you know that individual, quite often worked with that individual for a long period of time, so you are emotionally involved, and what we can do is take the emotion out of it and make it easier for you. Definitely a really good point there. So thank you so much for everybody that's attended this evening. If you do need any further information, you can contact me. You can either message me on Facebook, Instagram, or if you go to our website, www.fta-law.com, you'll find us under Meet the Team, and you'll find Sonia's and Abby's emails and direct dials. So you can always give us a buzz, and we'll be more than happy to help you. And thank you so much for you both joining me this evening. It's been really interesting panel discussion. And thank you to everybody who's joined us. Thank you so much.
Thank you very much.
Good night.
Thanks. Good evening. Thanks. Bye.
Bye.